In partnership with Singing Hills Memorial Park, welcome to Journey Home Radio, discussing the most important topics around life's most sacred goodbye. This is Journey Home Radio.
Hello, and welcome to Journey Home Radio, where farewell meets forever. If you have any questions about our segment today, comments, or ideas for us, you can reach us at singinghillsmemorialpark.com or reach us at 619-444-3000. I'm your host today, Thesa.
And I'm Cody.
And today we are joined by Mark Ignacio. We are going to discuss the different types of estate planning and how to protect your assets and what to expect when a loved one passes.
Thanks so much for joining us today, Mark. How's it going?
Oh, it's going well, guys. Thank you so much for having me. Appreciate it.
Absolutely. We're so excited for today's segment because I don't know about everyone else listening, but when I first started in this industry, I had next to zero knowledge about end-of-life affairs. And one of the most confusing bits was estates, trusts, wills. I mean, even figuring out the hierarchy of next of kin was a learning curve. So how about we just start by having you tell us a little bit about your background, how you got into it, and what really drew you to estate planning?
Yeah, certainly, Cody. So I have been a practicing attorney now for over 13 years. 13 years, and during that decade plus of experience, it's really been focused primarily with trust and estates law. So when we talk about the fun topics, right, of death and incapacity and the aftermath of that is all what we specifically do here in our firm and what I do specifically. So for the longest time, when I decided to pursue this path of being an attorney, I actually wanted to be a prosecutor. I saw all those cool shows, and it's like, oh man, that'd be really awesome to just be there in the courtroom. Learned really quick, especially with criminal law, that wasn't for me. It really wasn't for me. It got too real, too fast in that type of way, and that type of law didn't really fit my style and my personality. So the third year of law school here, unfortunately, my stepfather, he passed away, and he did have an estate plan, but regrettably, it was incomplete. And as a result, my mother and I had to go through the probate process. We had to spend a lot of money, a lot of time, go through the courts here. And it was all completely unnecessary, considering that we had an attorney, but we weren't really guided appropriately here. Right. Mm-hmm. And that's where I saw and I witnessed firsthand the effects of an improper estate plan and what they can have on the surviving loved ones. And that really resonated with me because that's what I really believe in. I want to provide this element that we can't really purchase, which is peace of mind, just peace of mind, mm-hmm. where in all respects, estate planning is truly this genuine act of love. Not so much and exclusively for the folks that we will be leaving behind, but also for us as well. I mean, there's just a lack now of self-love. And we try to provide this peace of mind throughout for the client and also for that generation that will leave the client eventually. So all of that, my personal experiences, my personality, what I ultimately want to provide for my clients, this all resonates here into ultimately being part of the estate planning and estate settlement type of law here.
So you said you had to go through probate court with your mom, and this was while you had already been studying law, right?
Right.
So for someone who actually knows about law and how things operate, it was difficult. So I can't even imagine, I mean, there's no amount of chat GPT that could help me with this. Zero.
And we didn't have chat GPT back in the day. And frankly, when I was still in law school, it was still law school land, right? So it's all, frankly, theoretical, not necessarily practical in the nature of what was going on. So that's where I like to bridge that gap from theoretical to reality to practicality here.
Mm-hmm.
And Mark, I have a question. What are the most common mistakes people make with their estate planning?
Yeah, that's a great question there, Thesa. So usually people come in and they are saying, you know what, we got something super easy. We got something that's simple. We got something that's basic. And as we all know, we're incredibly unique individuals with unique family circumstances and dynamics and financial situations as well. So more often than not, we get into the planning stages here. And we recognize that things are not so simple. Things are not so straightforward. Again, theoretically, it may sound great that, oh yeah, you know what? I have 2 kids and I don't want to necessarily favorite one over another, so I want both of them to be in charge. Well, as we dig deeper, we try to understand what's the relationship between those 2 kids of yours. Do they get along? Do they actually live close in town here? What are their work schedules like? What are their family dynamics like? So we help review the holistic approach of all these folks, especially when they come in and believe that something is so simple, and that's the issue there, right? Folks feel that they can kind of do this thing by themselves, and again, you don't know what you don't know here. Right. And we have to bridge that gap from theoretical to ultimately what will happen once the unthinkable happens when folks pass away.
And so I'm the middle of 5 kids, and you can't even get us to decide on pizza toppings, let alone what to do with assets. So for situations like those where parents set aside the delusion of, oh, my kids are going to be fine and they're going to get along perfectly after I'm gone, how can you make sure that it basically goes on autopilot? Like, what are some of the things in an estate trust that would help things run more smoothly and keep it from going to probate?
Right. So number one, it should be clearly defined. It should be in writing. I don't know how many clients I have where they're more from the traditional perspectives of, hey, you know what? I raised my kids correctly, and the oldest one is going to be the one making decisions. Everybody knows that. Well, that won't really fall well with a judge, right? If things haven't been explicitly laid out. So we need to make sure that things are actually laid out in place. And frankly, here too, Cody, we challenge that assertion that, hey, yeah, when I pass away, my kids are all going to get along. Well, we poke and prod at that assertion, right? Because guess what? What is the way and the only way to really confirm a trust or an estate plan will work is if you pass away, as if you ultimately are incapacitated. Well, we need to bring voice. We need to bring life to what you ultimately want. And that requires just an explicit opportunity here to put forth what is it that you want? What are some contingencies? What are some sort of tiebreakers here in case there can't be some sort of unanimous consent or majority consent? Because the last thing we need here is for the court to interpret what it is that you want.
Yeah, because the court's going to interpret things with the law's best interest at heart when it comes to those decisions. It's not necessarily going to focus on the loved ones. It's going to follow procedure. Am I getting that right?
Exactly. Yeah. So in seminars that I presently hold, I always ask, okay, here, who has an estate plan? Vast majority of people don't raise their hands. And I tell them, guess what? You actually do, because California specifically has already created one for you by default. And when I go through the issues of who gets priority over their stuff or who gets priority over decision-making processes, they typically don't like that. So here, estate planning is incredibly customized. So we want to make sure, again, the voice, the intentions, the wishes are going to be really held and heard and explicitly maintained there.
So you said California creates an estate for you. Is that so? I'm originally from Georgia. When I moved here, did they immediately create one? Is it like a 90-day period thing? Like, how does that work?
It's residence. It's based on residence there.
Gotcha.
Right. So where you vote, where you live, where you maintain your home, that will be the appropriate venue to determine which jurisdiction will hold.
Gotcha.
Yeah.
And so, I'm 33 years old. What's the best time? I mean, if California's already started one for me, it would make sense that I should probably have a hand in it, right? When's the best time to start thinking about estate planning?
As soon as you're an adult, in all honesty, as soon as you're an adult. Because once an individual turns 18, and it doesn't matter if they're college kids and they've been sheltered from the world, from their parents, as soon as somebody turns 18, you are a full-fledged adult, and your parents do not have the automatic right and authority to make decisions on your behalf. So generally, when folks turn 18, they should have a power of attorney already, a healthcare directive to specifically indicate who are the individuals that should make financial and personal decisions and medical decisions for them. But typically, there's going to be some triggers here, right? As far as, okay, gosh, adulting is taking on pretty quickly here, right? I just got married. I bought a home. I have a child. X, Y, and Z. Usually, when those factors are going to be upheld, and once you come into that and it's crystallized, that's when you want to maybe formalize your estate plan from maybe a will-based type of plan to more of a trust-based type of plan here.
Gotcha.
So, Mark, I didn't know until I got into the industry, the funeral industry, the difference between a trust and a will. Would you mind defining that for us?
100%. So it is such a misnomer here, right? Where people incorrectly say, "Oh yeah, I have my trust, I have my will done, and according to my will, X, Y, and Z get things." So let me kind of help break it down. Think of a will as a compass. It provides direction. You see the arrow pointing in whatever way, and this specifically includes your intentions of who gets to be your executor. An executor is to a will, right? As a trustee is to a trust. So you can dictate who is going to be the person that handles your affairs. You can dictate who gets your personal items, who gets your assets here, the distribution components. And in the will is the instrument where if you have minor children, you can specifically indicate who are going to be the guardians of your minor children. So obviously incredibly important to have a will. But where trust differs from that also provides those testamentary instructions of who gets what when you pass away. So as a will is to a compass, think of a trust as this container, this box, where you, as the grantor, we call it a grantor, you're going to create these rules associated with this trust. You're going to say, who is the successor trustee if you cannot manage this trust any longer based on death or incapacity? Well, who are going to be the beneficiaries upon you passing away? And what types of restrictions do you have on those gifts? And this box will contain all these rules. But you need to then fund that box. You need to retitle assets to reflect the ABC family trust is actually going to hold those assets. Because if you don't do that, then those items will not be in the trust and therefore could be subject to the probate proceedings. So everything that's held in trust with those appropriate rules will typically avoid probate. If it's not held in trust, and even if you have a will, you will necessarily have to go through probate.
You've mentioned a couple times assets, and there was this video I saw, I can't remember where it was, but it was kind of a rapid fire with an attorney of a liability versus an asset. And they were like both things you can own or possess. And so what do you think are some of the most commonly overlooked assets when it comes to estate planning?
Absolutely. So let me kind of go through that here in a bit, Cody. So usually the large value items that folks want to put into their trusts are going to be their property, their real property. You want to make sure that their bank accounts are going to be in there, investment accounts, again, just the big item things, right? But as far as the overlooked items are concerned, you want to make sure that any business interests that you have, if you own a mom and pop store, if you own an LLC, if you have an interest in an S Corp, you want to make sure that that is appropriately transferred into your trust. And you want to make sure that life insurance is going to be part of this as well. Because if you have a designated beneficiary to a life insurance policy and your trust says it's going to be going to a different beneficiary, guess what instrument will hold? It will be the life insurance policy because that's a contract. So the rule of contracts supersedes the law of wills and trusts. So we have to really understand all of this, right? Where if you want to give everything to your child, but that child's not supposed to receive anything until he's 35 years old, but you listed him as a beneficiary for your life insurance policy, guess what? He can acquire that those assets, those the the funds there immediately without having to wait until he's 35.
So there's overlapping parts and not everything is created equal. That's good to know.
It's not. So if you're creating a trust, you're already taking the time and energy and the resources to really ascertain in your life what's important and who's going to be getting what. It's now time to make sure that all of your assets are aligned with that principal purpose and that goal. So meaning you should make sure that the trust is specifically leveraged with all of those assets as well.
Gotcha.
Yeah.
And Mark, are there ways to protect your assets from taxes and creditors or lawsuits?
So yes, there are, and it comes in a couple of different levels here, Thesa. So one is there are things called irrevocable trusts. So as I discussed, a trust, think of it as a box, right, where you, who is the creator of the trust, will hold the powers to it. But you don't necessarily own it. So with an irrevocable trust, you can't make changes on those types of instruments. And if you have an irrevocable trust, that could certainly provide some savings for taxes and for liability purposes. But again, you have the caveat that you can't really change anything with that. So what we typically focus on are revocable trusts, things that you can make amendments to, family trusts, to avoid probate and make sure a lasting legacy is going to be happening. So with revocable trusts, it doesn't really provide some sort of protection in that initial level, but gosh, you can certainly create ongoing trusts for your kids once you pass away, where you can provide that type of protection to your kids if it's appropriately created, to minimize taxes, to limit any types of creditor claims. And gosh, we know that divorce rate, unfortunately, is incredibly high now in this country. Even in an event of divorce, it can help protect that.
If you're just now joining us, I am Cody Spradlin with Thesa Miele from Singing Hills Memorial Park, and we are joined by estate attorney Mark Ignacio from Mark Ignacio Law. And today we're talking about estates and basically everything that goes into them. So we were just talking about revocable and irrevocable trusts. And my question would be, how often should you review and update a trust, whether revocable or irrevocable?
Right. So that's a great question there, Cody. I mean, when you create a trust, there's such a misnomer here that, gosh, I've done it. I'm set. I'm good to go. But especially with a revocable trust, the elements, the rules that you created initially, they may change over the years. Your life will likely change between now and 2, 3, 10, 15 years from now. And you want to make sure that those goals, those wishes are continued to be upheld and maintained during your life. So there's not a set type of many years that you should often be changing these. It's really based on life circumstances. And some of the main triggers are, okay, was there a new addition to the family? Is there a death in the family? Were there new assets acquired? Were the relationships between the people that you initially put on the instrument, have that changed? Has that soured? Has that become much more pleasant? Those are the main triggers that we specifically look at and kind of establish a punch list of, hey, if one of these things happen, you should probably have this trust renewed and reviewed at least.
Great. Thank you, Mark. And so if someone comes to you and they want to begin a trust, what do people need to bring to you?
Yeah, so similar to how you go to an initial doctor's visit and the doctor will require a history of your health, that's something that's going to be important for us where, hey, if you're going to be meeting with us, we would like you to complete a questionnaire that allows us to understand the nature of your family, the nature of your assets, so that when we ultimately meet, we're not going to necessarily be filling out a chart, filling out a client organizer together. We would already have that information so that we can just have a conversation. I want to be really able to get to know the other client here and understand their story. Again, most likely they're going to be coming in indicating that we're very simple, very boring, very, just hands off, but we want to challenge that assertion. Because again, once they are no longer around, that's how we can really test whether that instrument will actually work. So come in, complete that client organizer. We'll have a good foundation of where we're at, and we'll have a conversation as far as what your needs, wishes, goals are, and how you want the family dynamics to be moving forward.
And how long does the process usually take to put a trust together?
It really varies, So we provide comprehensive estate plans. So we have trusts, wills, powers of attorney, healthcare directives, right? And we have a pretty decent process here with our team. So it can last anywhere from about 4 to 6 weeks. 4 to 6 weeks from the initial design meeting to ultimately when everything is going to be finalized. Depending on exigent circumstances, if folks are going to be having surgery, if they're going to be going out of town, we can certainly make accommodations to make it shorter time frame. But usually with us, it's about 4 to 6 weeks.
That's still not as long as I thought it would take. I thought it would be way longer. A few months at least.
I did too.
Yeah, and we have a really great system here, really great employees here and our staff that acknowledge and know what they're going to be doing, and we have a 3-tiered type of review process here. So we make sure that things are flowing well. We definitely require the client's cooperation to give us further information that we're requiring. So long as all hands are on deck, 4 to 6 week turnaround is definitely something normal that we can produce.
Nice. So we were talking earlier about, reviewing, changing, adding, all that kind of stuff. Yeah. For people who already have a trust in place, what are some new laws or tax changes that have occurred, might occur recently, that you think people should know about?
Yeah, so big thing here, Cody, is that, gosh, when I die, does my estate have to owe an estate tax, right? Where a lot of the goals that were established here is to help preserve the wealth specifically for the family. So with the new administration here, vast majority of people don't have to worry about the estate taxes because that threshold is incredibly high for the estate to owe any taxes. Presently, it's at $15 million, around $15 million. So if you have assets that are worth over $15 million, then Uncle Sam will get 40% of that. But a vast majority of people are under that, right? Under that threshold.
I was about to say, I'm in the clear.
Just slipped under, right? Just slip right under there, Cody. So one of those things, like with older trusts, there were these A and B components where the threshold was incredibly low back in the day. So we may not even need those A-B types of trust components anymore, just to make things a little bit clearer. And as far as new other taxes here, there isn't anything too relevant that will require an immediate change, but it's really the family dynamics, the family circumstances that would really engender people to make sure that their goals, their wishes are going to be upheld in the current state of affairs. Because as I mentioned before, hey, you may have guardianship provisions back in the day. Now your kids are all older. Now your kids likely are going to be the ones that will be your successor trustees, no longer your siblings or your parents here, right? Maybe your parents have passed away and they don't need to be part of the trust any longer. So those are the things that we want some facelifts for the existing trusts that have.
So let's say you do have, like, your parents passed, they had an estate in place, you inherit that estate. Let's say you're an only child. Yeah. If you already have an estate, can you just pick up that box and put it inside your box?
It all depends. It all depends on how that initial plan was created. If your parents were like, we want to give everything to our son Cody, he's our only child, we love him dearly, and we give it to him outright, in an outright fashion. Okay, that's yours. You can do whatever you want with it. But if they specifically put rules there that says, Cody can't inherit anything until he's 35, 40 years old, and his Uncle Jimmy is going to be the one that needs to manage this for his life, then we have to follow the rules of what parents have wanted.
And so if someone wanted to get in touch with you or maybe attend one of your seminars, what would be the best way for them to do that?
Yeah, thank you for that. So the best way really is just to go through our website, ignaciolaw.com. There's a great wealth of information, resources there. You can click on that banner to indicate you want to register for an upcoming seminar. And that's a really great non-confrontational way to meet me. I know that folks are really seem to be scared from meeting attorneys. So that is a great non-confrontational way, again, to initially meet with me and just register there. We have it at least once a month here moving forward.
Very cool. Well, thank you so much for joining us today. Again, if anyone has any questions, comments, or suggestions about this content, past content, future content, feel free to reach out to us at singinghillsmemorialpark.com or call us at 619-444-3000. I'm Cody.
I'm Thesa.
And this is Mark.
And thank you all for joining us. We will see you next week.
Thank you for listening to Journey Home Radio. We look forward to talking with you again next Saturday at noon right here on K-Praise.